I hold a BUris degree as well as an LLB from the University of the North then, and now University of Limpopo. I also hold a higher diploma in legal drafting from the University of South Africa. I am a mediator qualified through the Law Society of South Africa, and I've been admitted as an advocate for the last 27 years, that is since the 1st of October 1996. I worked in the public service. I joined the public service formally. I'm saying formally because there are other things, public service, that one did prior to 1994. But in 1995, I was integrated into the South African Police from the ANC, and I was then given the rank of superintendent at the time in the police. That is when the non-statutory forces and the other Homeland Police and South African Police were merging together to form what we now call the South African Police Service. And in 1997, I moved on to the office of the Premier, where I was appointed as the Chief of Staff to the then Premier of the province. I stayed there for 8 years in the office of the Premier. In 2005, I then moved on to Anglo Platinum, where I was appointed as a legal officer there. But in 2011, came back to the public service, served as the special advisor to the Minister of COGTA, and later appointed in the same department as the Deputy Director General for Traditional Affairs until when the contract ended, I rejoined the bar back to practice as an advocate. Now, my practice as an advocate has exposed me to ability to process difficult cases. I hear people talk about big cases and small cases, but for me, every case that comes before me or that I have to prosecute or execute is the same, because even if, for instance, it's a delictual claim, someone is claiming 300,000, I'm giving an example of a rough claim, a Rolex and Fund claim. Even if someone is claiming 300,000 and the other is claiming 900 million, or 9 million, that amount, or that the client or the plaintiff at the time will be feeling same, irrespective of the amount of money or the injuries that one would have suffered. So, for me, therefore, one has been able to deal with cases as they come, and understanding that we are now talking about the public protector. For me, therefore, before the public protector, there will not be a small or big case, important or less important case, because every complainant that approaches the public protector would be regarded as the same. We are operating within the rule of law context where, access to justice should be common to all. All are equal before the law and should feel and be seen as being equal before the law. But then, Chairperson, I also, in the career that I've outlined, also served community service. I was a national chairperson of the South African Geographical Names Council, which was processing names around the country of cities and places. And I'm sure many of you now from places with new names, Makhanda, Polokwane, Mbombela, and so on. That is the legacy that one has been part of and has led in creating, because I believe that, the names of places will live with all of us to eternity. Now that some are living in the new named cities, that is a heritage that we will carry forever into the future. And I was part of that architecture. I was part of the building of that legacy. I also served in the National Heritage Council. which was or is a body created by a statute within the Department of Arts and Culture, which serves to preserve and identify heritage sites, preserve those, and make sure that they are kept for the future. I also have been a trustee chairperson in the MedShield medical scheme, where, you know, as trustees, you serve to protect the interest of members of the medical scheme. It is a community service that you do, and make sure that, you know, all those who having various ailments are taken care of, and the medical scheme responds adequately. And, you know, that service one, I believe, has executed with extreme care, and I was serving as the trustee responsible for the legal affairs of the medical scheme, and I think I executed myself well. We haven't had complaints during our term, and the medical scheme continues to serve its members. I am chairperson currently serving in the disciplinary committee of the Legal Practice Council. There we process complaints by members of the public against rogue attorneys or legal practitioners. You know, you would know that there are various complaints by various people, particularly victims of accidents against lawyers who steal or embezzle compensations from Road Accident Fund, from Department of Health, and so on. And we deal with that and recommend appropriate action by the Legal Practice Council, and in most cases is striking those kind from the role. I'm also serving in the Audit and Risk Committee of the Gert Sibande College. I chose to go into a college, a TVET college, or a continuing education college, to serve there, because I believe that we need to intervene at the lowest level in creating the necessary skills and making sure that the colleges of education, the TVET colleges, as you would understand, you know, are able to produce skills that are essential for the country, because we believe that the country now needs technical skills instead, not necessarily against the academic skills as you find from universities, but I believe that we need to ensure that the production of those technical skills from colleges, practical, plumbing, and so on and so on, those skills must be maximized. And I chose to respond to the call to join the Audit and Risk Committee there to ensure that I'm able to contribute at that level. Chairperson, I'm also...
Yes, I didn't want to cut you short.
Yes.
A lot of what you are saying now is in your CV.
Yes, yes.
And just one question from my side. Besides having been a police between 1995 and 1997, have you been exposed in any investigative work?
No, no. Let me say that the training on investigation is what I got when I formally joined or was integrated into the police services. So that's where we're trained in detective work, gathering information, interpreting the information into intelligence, and then that intelligence will then be used by visible policing to know where the crime hotspots are, and you know, use that information, that intelligence appropriately to fight crime. So that's where we are.
Thank you very much. Do you confirm the disclosures you made in the questionnaire? If yes, is there anything else that you wish to add or explain?
There is nothing more to disclose, Chairperson. All that has been disclosed is what is disclosable.
Thank you very much. So now you have the opportunity with the colleagues on my right. Each colleague has 8 minutes with you. It's the opportunity for the colleagues now to ask questions. Right. I'll start with to the same order. Must I follow the same order, colleagues?
Yeah.
Agreed. All right. All right. Okay, so now I will start with, you see, if I stick to the same order in terms of, not because you may, right, Makonisha may not want to come in first, for example. In that way, I will exchange it with Maina Lisoma. Honorable Lisoma? So it will be, all right, so it will be Honorable Lisoma, Advocate Bredenbach, Mota, I don't know who you want to swap with. Okay, thank you. Inkosim Telezi, confirmed? Confirmed. And Honorable Tape, confirmed. And Honorable Horn, confirmed. Honorable Vessels, confirmed. And Honorable Mananise, confirmed. Honorable Janji, confirmed. Janji, confirmed. Thank you so much. All right, so in that order, I start with you, Honorable Lesoma. Oh, Makwanisha, was it not? Yes, Makwanisha? All right, so Makwanisha will come in at the end. All right. Honorable Lesoma?
You know, I saw that. Chair, good morning, Advocate
Morning.
Siwa. And one should appreciate that you took trouble to have an interest to serve the country. Having said that, and I've gone through your CV, equally yourself, also your good self, you would have gone through the previous AG's or Auditor General's reports around the public protector as the office, not the individual, and also issues that you would have been raised there. Having said that, just quickly, we are in a situation in South Africa with limited resources, as it were, economically and socially, in terms of fiscal challenges that we have. But in your introductory remark, you made a very noticeable point for me. As a citizen with a history of activism, having served in various capabilities or capacity in government, what interventions would you employ to undertake to advance the paradigm which caps the non-compliance in government and the continued fastening in maladministration and corruption, because maladministration and corruption, they are not the same, but they look the same. And also what innovative issues or mechanisms you will employ to ensure that the turnaround expected, because it's not written anywhere, expected turnaround of the public protector in terms of the issues, and also profiling of those issues, categorizing of those issues that service the citizens, general citizens, other than those who find expression or media interest or public space interest, as it were. Thank you, Chair.
The resources, I've indeed looked at the state of affairs at the Public Protector's Office, and I think the major problem is indeed funding of the Public Protector. There are various proposals that have been made regarding or with regard to improving the finances of the Public Protector, and I was myself thinking deeply about what can be done, and among the proposals that I thought I would present to the committee was that the 350 million that is being given to the Public Protector is definitely not adequate, but the proposal is that we may look at creating a special fund, a fund like you have with the Road Accident Fund, for instance, where, you know, there is a special contribution by from the fuel that people are buying every day. But with the Road Accident Fund, with the Public Protector, the funding could be that we say that each department, we create an anti-corruption fund or a good governance fund, depending on whether you want to be positive with the name, a good governance fund where each department can contribute, for instance, 1% of their budget into that fund, which can then fund all anti-corruption or maladministration, anti-maladministration funds, including the Public Protector. I know that the Zondo Commission has also proposed, that there should be a special body to fight corruption. But my sense is that that anti-corruption fund that the Zondo Commission proposed should actually be merged with the public protector somehow to ensure that the fight against corruption is consolidated into one body, and the funding is not, spread across. And because I believe that if there are so many bodies all with the aim of fighting corruption, we may find that the effort is scattered and therefore ineffective. So my proposal, firmly, regarding resources, gathering resources, consolidating, is that a special fund be created where all the departments, all the SOEs contribute a percentage of their budget into that fund to fund the war on corruption, the war on maladministration. Now, regarding cases, as I said, Honorable Member, my sense is that there is no big or small case. Whether it's a case against the president or it's a case from Tanzania by a villager from Tanzania, those cases to the public protector, they must be graded and treated as of equal weight, so that you do not fall into the default of treating cases that involve high-profile people, with agency, and then in the process marginalize those of ordinary people that are reported as complaints from the public. So you need, therefore, to give them the similar space. And as I was saying earlier, giving examples of the amount that people claim. Because the law is the same, whether it's a small case or a small claim case or big case involving a member of the executive. So for me, therefore, those cases will be treated equally. Obviously, the resources may not be equally deployed given the sizes, but I would want to see all cases from big or small persons or about big or small persons equally prioritized and dealt with. That's how I would respond to the question.
Okay, thank you, Chair. And I do have a view. I think I just need to register it. The Rafa example is quite a wrong and a very wrong example. And I'm sure that, and also in your mind, you are also aware of the gaps and abuse of that by the middle person in between the person that would have been affected by the accident and also the end user and also the processes that are there. But I'll leave it to you, but I think it's quite a wrong example for me, but it's my position. Chair, Section 182 of 4 of the Constitution of the Republic does say the public protector is accessible to all persons. Achieving this mandate can be challenging in some times. Also with the question that I raised, because I just want you to amplify on that one, that do you appreciate that the fiscal constraints, but you have said that the special fund, but it doesn't address this South Africa government as a country. We've got fiscal challenge in terms of disposable money that can be used, informed by various factors. You made an innovative one, but I want to go to the space of using the technology. Would it be the best one? I must lead you on this one.
So you will have 1 minute worth of response.
Yeah, because it's one question actually. I want him to be straight to the point, that's why.
Yes.
And we are taking my minute as well.
Yeah, thank you, Member.
Can I continue?
All right.
In terms of using technology, that you've got two communities, one urban, affluent with connectivity, and also those ones who are in the rural. So when you respond, also you must be mindful of that, because they are also having their hopes to the public protector. Thank you, Chair.
Thanks. Yeah, thanks, Honorable Member. The issue of funding, just to expatiate, I've read the reports of the Public Protector, the APP, And I see there they are also proposing that each department must pay for the investigation that are undertaken against them. Like you have the Auditor General of South Africa. If they audit a department, the department carries the expenses for that. So that's another innovation which I think I would look at, explore what is possible, and together with what I proposed of a special fund, try to match them. Now, regarding access, what the former President Beki once said, there's a second economy and the first economy. Now, you would find, therefore, that if you focus on digitalizing access to the public protector, you may in fact find yourself marginalizing the majority of the people of South Africa in the rural areas who are not able to send information. I have seen this in the NSFAS, where students in the rural areas are even currently unable to upload their information for their appeals when appealing against the non-funding and so on, because they are in the far-flung areas in the rural area. So that's the problem of digitalization. Now, the thinking that one has is that you need to exploit the fact that, since 1994, we now have the community radios, which are focused on specific communities. Now, I would partner with community radios, community media, and make sure that, the public protector then extends his or her reach to those communities through their community stations. But I'm also thinking that I would develop a campaign that I call Public Protector Meets the People, where the public protector will go to various provinces, organize what politicians would call imbizos, but I call it Public Protector Meets the People, where you then spend time in each province, where people then have access to the public protector directly, but also ensure that the offices in the provinces are enabled to themselves, even without the national office descending into provinces. They are themselves able to visit communities, cause those public meetings, and enable people to present whatever grievances they may have. At the same time, for the elite and those who have got access to resources, then strengthen the digital arm, where people can then submit their grievances, submit their complaints digitally without having to travel to Pretoria and so on. So there should be a balance between the rural and the poor, the rural and the urban, the poor and the rich, and all that. So that's what I will do and will be doing as the new public protector.
I'm trying to manage time.
Yes.
But it's not directed to you, it's directed to the colleagues on the right, that both the questions and the answers must be within the 10 minutes. Yeah, sorry, the 8 minutes. If you can stick to that. Thank you very much. And the next colleague, it's Bredenbach. Yes, it's a self-advocate, Bredenbach.
Thank you. Good morning, sir.
Good morning, Gansan.
I see that you say you're an ardent reader. What are the last 3 books you have read?
I've been reading the book on the former president, Thabo Mbeki, I know. I've been reading Malangana, the Little Sons. I'm currently reading the book by, I forget the author, but it's Takalani. It's about the life up there in the far north. And many more. But you said 3. So, okay.
What do you understand under the legality?
Principle of legality relates to the rule of law, Honorable Counsel. It relates to the rule of law that all of us are equal before the law. The law must be accessible to each and everyone, irrespective of one status in society. And the law must be seen to be fair, to be non-discriminatory, and that all of us should feel that even as it is expressed that we are equal before the law, we should all feel equal before the law, and it must be seen by others as such. Because once that is interfered with, then the confidence in the legal system dwindles, and if that is allowed to go on, then it brings chaos.
All right, well, that's problematic, because my next question is, what do you understand under the rule of law?
Oh, so I've sort of
Now, you
preempted.
told me what you understand under the rule of law, but I asked about the principle of legality.
Yes. All right. Yes. So I have already dealt with the rule of law, and I think that relates also to, the legality aspect will also refer to, the fact that once something is, or some case is introduced into the legal system, it follows that process, is not interfered with. There is no bigger person or bigger individual or bigger office that can interfere with the due processes that cases have to follow. Because, as we may have seen that in the past, or perhaps even currently, where you find that dockets go missing and so on, where bigger, people with money or bigger influence interfere with the legal process. So you would want the due processes of the law to be allowed to take their course without fear, without favor, and with no prejudice coming in and interfering with that process, with those processes.
The Constitution of South Africa says that the Republic of South Africa is founded on the supremacy of the Constitution and the rule of law. What do you understand this to mean?
Thank you, Chairperson. Prior to 1994, we had Parliament being the sovereign lawmaker, that everything, all the law was subject to the sovereignty of Parliament. But as we would know, that since 1994, the Constitution has become the main law. All laws are subsumed into the Constitution. As Judge Chakalson said in the Sarfu case in 2000, that all laws that we have in the country must be subject to the Constitution. Anything that is not in line with the Constitution is therefore invalid and unlawful. Even the judges, as they interpret the law, they must interpret that from the basis of the Constitution as the basis for all law. Now, that therefore underpins the rule of law, as I explained earlier, that whatever is not subject or is not in accordance with the Constitution is therefore deemed invalid and unlawful. So all such conduct that is outside the constitutional confines becomes invalid and unlawful, should anyone dare to act outside those realms.
You are hoping to be appointed to a position of leadership in an office that is very important constitutionally. The office currently is deeply divided, conflicted. How do you propose to get this office working optimally in a short space of time?
I think as a leader, you need to rally your forces to focus on the target, on the strategic objective of the office that you are dealing with. And the strategic objective or the vision of the public protector is to eliminate corruption, maladministration, and impropriety. And you need to rally all the forces around that objective. And of course, unfortunately, those not willing to be rallied around that objective will have to give way for the office to run smoothly. Now, the mandate of the public protector is very clear. Well, it is unfortunate that, as we have seen in the case of, or perhaps let me say that, as I said, that constitution reigns supreme. If you look at the case of the West...
Let me interrupt you briefly.
Yes.
You have 1 minute left.
Okay.
How are you going to fix the office?
Get staffers to focus on what is on the work at hand. Make sure that no one is distracted, no one is partisan. You know, remove the partisanship that may have been there in the past. Make sure that all are focused on the target and the strategic objective of the office, which is outlined in section 182 of the Constitution.
Thank you, Mr. Chair.
Thank you very much, Honorable Mawute.
Thank you, Chair. Tobela, Advocate Nsem.
Shate,
Lega.
Rwanda guy,
So, on your CV, you are a member of the Audit and Risk Committee at Khersiwande, but you're also the chairperson of the Tribunal Appeals, NFSAS, Appeals Tribunal. So, given these experiences, how do you view the call by students in higher learning, higher institutions for free decolonized education?
The education, you know, I read somewhere that education, the concept of education, taking people to class, started officially around, I mean, in Finland somewhere. And the purpose was to produce workers that will be able to satisfy the employer, being the capital at the time and so on. Now, given the change of times, education must always and everywhere be responsive to the challenges of the time. We have been through colonial education. You know, me and you would have been taught about Jan van Riebeeck as the beginning of history in 1652. So we need to ensure that we teach our young people that there was life before Jan van Riebeeck, there was life before Europe came to know about other continents other than themselves. So indeed, we need education that responds to the current situation, and our youth are entitled to be taught relevantly so that they can impact on the future. So I agree with decolonization of education, relevant education, education that is responsive. I do agree.
Suppose you become the successful candidate. Can you give us, in your view, the three main or key risks that the Office of the PP is facing and how you intend to mitigate those risks?
I think, as Honorable Advocate Roten, Honorable Advocate said earlier, among others, she said it's a division of staff. So I think for us to be able to move forward, you need to deal with that. You know, raise the morale of staff, make sure that they are not distracted by particularly partisan politics, and they focus on the issue at hand. But secondly, I think it's the funding, which I've already spoken about. We need to make sure that these issues around funding are crystallized, they are discussed at the high level to make sure that the public protector is able to intervene decisively in ensuring that the work of the public protector is not disturbed. Access, as has been said, people, you know, see the public protector as this elite organization based perhaps in Pretoria, seen only on TV. So you need to make sure that you are able to reach out to the peripheral and far-flung areas of the country to make sure that the public protector has an impact and is accessed by all.
Thank you. So your last two public service roles were associated with ministerial or political offices before you went on private.
Yes.
So while you've mentioned through your correspondence that you remain committed to remaining free from party political bias if you get appointed, how would you address concerns about your prior close proximity to politicians, particularly at the senior level? And how would you manage and ensure that there's no undue influence?
Well, I found myself working in those environments, but as I said, before 1994, I worked, or 1995, I was deployed, or let me say, integrated into the South African Police Service. And in the South African Police Service, you deal with people as they come, irrespective of your political alignment in the past and all that. And for me, I've been trained as a lawyer, and I know that there are instances where you represent a particular defendant. The other day you represent a claimant who may be against the government, and the other day is the other way. So that's part of my training, to be able to act fairly, to act reasonably, to ensure that, honestly, and on all that. It's ingrained in my training. So even as I got involved in the struggle against apartheid, that was driven by that understanding that there is what is fair, there is what is unjust, there is what is not good. And therefore, that propelled me to get involved in that just struggle against apartheid. So in that context, therefore, my political alignment of the past should not in any way influence my decisions today, as like it has been demonstrated that even currently, the kind of work I do in the structures that I serve as outlined, they would obviously be different stakeholders coming from various political persuasions. But when it comes to that work, you don't look as to whether the student comes from EFF Student Command or ANC Youth League or DA students and so on. That doesn't feature at all. And
That's fine. That's fine for now.
Okay.
I'm pressed for time. So in your response to the challenges facing South Africa, one of the things you've listed, it's not the only thing, is that you've identified that you've got a problem of abuse of power by public representatives. What did you mean by that? Can you delve deeper into that and give us practical examples where you faced a situation where there was political influence, abuse of power by politicians?
I come from a rural area in Limpopo. And what I see there happening is that, well, despite the case of the, I think it's Kasak against the Ingonyama Trust, ordinary people continue to pay taxes, extra taxes, to traditional leaders. That's called levy. That is, they pay for their right to occupy or permission to occupy the land that historically belongs to them. I see that as a continuous neglect of duty on the part of government, in that particularly because there is a government, a court order, even though it's a KwaZulu-Natal court order, but the ramifications are across the provinces. So the fact that that court order is not being implemented, for me, constitutes continuous abuse of power by those who can intervene to just make sure that rural people also can claim a piece of land and say, this is my land, I live here, I'm entitled to it, it's my ancestral land. Because most of them, they only have permission to occupy. And I've seen traditional leaders willy-nilly taking away the plowing fields, taking away the land that belongs to the people.
Okay, let's
without
pause there.
intervention.
Sorry,
The last
can I cut you now? You've gone over your time.
Have I?
Yes, by just a few seconds. Nkosi Teles.
Thank you very much, Chair. I've got very few questions that are very pointed, Advocate. Firstly, I want to build up on a question that has been already asked here in terms of the exposure of this office to political interference. You have assured us that you are a strong person in relation to the absolute integrity that is required from the incumbent. Can you just refer us to one instance where you have proved yourself that you are strong and not easily influenced, practically? If there is. If none, that's okay.
Well, I've chaired the South African Geographical Names Council. There was an incident when the town Tzaneen was up for renaming. There were communities. And at that time, the MEC who was responsible made a pronouncement that Tzaneen will be named Mark Shopper. So that he preempted processes. And as chairperson of the committee at the time, based also in Limpopo, very close to the MEC, you know, I expressed to him that MEC, this is not the right way of doing it because you are preempting the process. By pronouncing that this town will be Mark Shopper, you are now overruling all the processes that have to be followed. And indeed, when communities met, they then reaffirmed their name, Tzaneen, and said, no, Tzaneen is an African name for a basket, and therefore, it's a geographical, the landscape there resembles a basket. And they rejected, unfortunately or fortunately for the MEC, the name Mark Shopper. So I impressed upon him that it is important to follow process, irrespective of where you are in the hierarchy.
Is that the same scenario where you were requested to withdraw as the chair?
No, that one was a different one. That was
take us into your confidence in terms of what were the reasons that
that was about the renaming of Makado.
Oh, okay.
So communities in that area, some were saying Makado. So the case came before us. We accepted the case, and the matter. They took the matter for review in court, and indeed the court in Pretoria, the High Court, said that the consultation process was inadequate, and the order was that we should go back and make sure that there is adequate consultation. And that was in the process of developing the jurisprudence around Section 33 of the Constitution, administrative justice, to make sure that, and I'm very grateful for that. So obviously those who were against the change of name were then saying, yeah, advocate must go because must step down because. But I went then back to them to explain that, look, the courts are the final arbiters. Courts are the final arbiters. We need to accept that whatever we do as administrators finally goes to the court for arbitration, and
just to test your honesty.
Yes.
In execution of any of your jobs, have you ever come to a point where you have to knowingly go against something that is permissible, and what was that?
I've never done something that was impermissible deliberately, and no, there's none.
Okay. Then my last question, Honorable Chair, how do you think you can use this office if you are given a chance to advance the agenda of our country in terms of the imbalances of the past and also addressing the socio-economic challenges that are faced by our people?
Chairperson, the concept, the apartheid on its own as a system of government was based on a corrupt system that will favor others against others. So that on its own was corruption. So the defeat of apartheid for me.
Just get to how are you going to use the office? Don't explain.
Oh, okay.
Yeah, the apartheid and all that. How are you going to use this office to advance the agenda of the country in terms of the two issues I've alluded to?
Use the office, Chairperson, will be to, without fear or favor, without prejudice, go for any source of corruption, go against any source of maladministration, wherever it rears its ugly head, without fear or favor, irrespective of the position and influence of a particular person involved.
Efficient.
Thank you very much, Honorable Tlhapane.
It's for
Thank you, Chair. Adumela Ntate Nzo.
I'm
I just want to focus a bit on your questionnaire. One of the issues that you indicate that we will bring or we will do is that the contempt of or non-implementation of court orders by various spheres of government or departments shall attract unsolicited investigation, and if found, shall be deemed as maladministration. Now, we're talking here, as you've been the candidate of an institution that has struggled over the years with backlog of cases, and you want to do some voluntary work somewhere, run around for unsolicited investigations. How will you want to reduce the turnaround time of complaints, including backlogs in the OPP? And in addition, how will you achieve this without compromising the quality of reports?
Yeah. The Act, the Constitution and the Act, of course, allows the public protector to, on its own initiative, to initiate investigations, because obviously there may be instances like the one I've just referred to of the court case against the Ngonyama Trust, people paying levy and all that, not being followed up. For me, that's maladministration, but that's a discussion for another day. Now, regarding dealing with the backlog, you know, the Supreme Court rules calls for mediation as another way of resolving disputes and intervening in areas where people are not agreeing. So I'll look at mediation, you know, mediate between parties so that they attend to whatever gap that shall have been identified. Now, regarding turnaround time, this also refers to or involves the area that we refer to of funding of the public protector, which means we may have to look at increasing investigators so that the backlog, I hear that they are about, I mean, the public protector deals with about 40,000 cases a year, and we have to make sure that such cases are dealt with and finalized. Now, we may have to look at, once we resolve the issue of funding, look at bringing in more investigators, but with mediation, I believe that some of the cases can be resolved without even having to go to court, as we have seen, and you know, being through a protracted process that can be resolved by mediation. The public protector awards or remedial action are binding. Now, which means that when the public protector issues a remedial action, then there will be timeframes within which to act, and failure to act will be accompanied, obviously, by sanction, a concomitant sanction appropriate to the non-compliance. So that will be dealing with the time frame and the response times.
Right. Now, Advocate Panyane, what would you say is your leadership philosophy? And do you believe you have the necessary leadership skills for this position?
Chairperson, I think my track record speaks for itself. It's in my CV. I've led in various organizations and structures that I've been through. And in all instances, I know that I have done my best to be fair, to act with honesty, to avoid conflict of interest. So, in all, I believe that I'm fit and proper to take up the position of public protector and serve my country, given what I've already demonstrated in the short life that I've had in the public service and elsewhere, where I've intervened decisively. You know, this reminds me of a situation when I was still at university. We had a problem with rape. Women, young students complaining of rape. Every weekend there would be rape. And we decided at the time, and I was chairperson of the housing committee in the SRC at Cheflot, we decided that the best way is to integrate residences, because we didn't have the necessary policing to do and so on. But if men and women could come together, they would, like they do in their homes, guard each other. The young men will guard the girls. And indeed, the crime of rape on campus reduced drastically by just integrating the residents. And of course, that prompted the renaming of the residents, because most of them were MBA for men, VF for Frowens, and so on. So in that way, therefore, some of the creative ways
The
that
chair is
one is
looking
employed.
at me as I'm interrupting. I'm trying to get your leadership philosophy, but maybe let me ask you this one. Or how would have those who have worked with you describe your leadership style?
They would describe me as fair, as equitable, as honest, and as principled.
The leadership style.
And perhaps the style then will be collective leadership, participative, yes, involving all, making sure, democratic in a way. Let me say democratic. I think that covers participation and fairness and all that. So,
Yeah, you've saved a few seconds. Thank you very much. I now move to Honorable Horn.
Thank you, Chair. Good afternoon, sir. You've already touched a bit on the need for impartiality and objectivity in the role of the public protector. Now, of course, we sit with a situation that in terms of our constitution, having served as 10 years as a member of parliament would also qualify somebody. So I must at the outset pretext my question by saying I don't think the drafters of the constitution ever contemplated that nobody who's been politically involved can ever serve as the public protector. But in your specific case, you have deep roots in the struggle and specifically involvement in the ANC and ANC-aligned bodies. So how will you prevent that history from putting you in a situation where your impartiality and objectivity can be questioned?
thank you, Chairperson. Being involved in struggle, I think, was a duty on all young people of my time, such that not being involved really is something that it's unfortunate. But I think all of us at the time had to be involved, and I got involved at a very young age of 15, and I found myself in detention under state of emergency in 1986. So that history I'm very proud of and I cherish, because I had to be there. Now, but I understood from the beginning that the country that we are fighting for, the society that we want to establish, is a society that should be fair. It's a society that where everyone, the people shall govern, as it says in the Freedom Charter, where everyone will have the right to participate. And we understood that not everybody would be aligned to the ruling party and all that. And that is why, you know, when I was still a student at TEF, when 1992, when the Harare Declaration of the ANC was published, it had in it the area of the ombudsman, and that you would find also in the Ready to Govern document of the ANC. And as a young law student, we read that with enthusiasm because we saw that in our books about this. So we're already doing comparative studies. And those introduced to us as young law students that if structures like ombudsman and so on the ANC is proposing, it means that there should be people who would be non-partisan, who would serve in those structures. And, you know, we're open to that. And being an ANC activist, so the ANC in a way opened me to the possibility of, despite your membership, you can still be non-partisan and serve the public without fear, without favor, without prejudice. You need to make sure that happens. And because we also knew that there would be judges, there would be public protector, there would be this. All those people have to serve their people without fear, without prejudice. And so therefore the political alignment, the political prejudice will not, in my case, given the training that I've had since I was 15 years, will not interfere with the value of my judgment or the way I see things. Take each case as it's presented and make a fair ruling without prejudice. So that defines me.
Okay. Then I want to move on to, I think it's the questionnaire, and specifically your answers to question 1, which was why you are the right person. And then from 114 onwards, you give answers to the effect that you really want this job because you want to, as you call it, build an efficient and effective public service. So apart from dealing with maladministration, what is the involvement of the public protector in building an effective public service?
Chairperson, corruption or maladministration, sometimes people do it without committing. So I'm saying that I will want to collaborate with other institutions like the National School of Government, you know, in ensuring that the training of people on ethics and so on is maximized. Make sure that people know what is wrong and what is right. Because sometimes people, as I said, commit these things unconsciously, let me put it that way. So you need to maximize training, make sure that those who have the responsibility to train do it and do it correctly and effectively. So for me, therefore, the training of the public servants will contribute towards building that effective public service. Because as the National Development Plan is saying, that corruption is an impediment to building an equitable society that we want to build. It's an impediment to a better life that we want to give to all the people. And the public service is at the center of that. So in a way, you know, sometimes when something is built, it's growing, it on its own, it diminishes the other. So as we build together a public service that is efficient and effective, it means the work of the public protector on its own will become less and less if there is less corruption. So should we build that public service?
Thank you. Can you explain to me the concept of making yourself guilty of corruption in an unconscious way?
No, all I'm saying is that ignorance is a problem. So if for instance, or let me put it this way, that if you follow the cases, even though they are not about corruption, the cases that since the Ngandla case up to now, you'd find that the public protector was found to have been ignorant of the law, to have been this and that, to have ignored this provision and so on. And I want to take it that all those transgressions that led to the Section 194 committee finding the public protector incapable or incompetent, those transactions were not done consciously, and I take it deliberate. You'd find that it was because of lack of exposure, lack of training, lack of knowledge that those were committed. You know, so I'm saying that, and you'd know that sometimes by omission you can commit a crime. By not helping someone who's being attacked by others, that is by omitting to act, you may find that you commit a crime. You become an accomplice to a crime. So it is in that context that ignorance can give rise to a criminal offense.
Okay.
By not doing anything, you become criminal.
My time has run out, unfortunately. Thank you, Chair.
Thank you so much, Honorable Hon. Now move to Honorable Vessels. Thank you very much.
Thank you, Chairperson. Good afternoon, sir. I also want to go to the answers to the questionnaire. And you, in one of the answers, say that if you are the successful candidate, you would extend the focus of the public protector to local government. How would you do that, and what do you mean by that?
I gave an example of the Auditor General's reports. I think in the last Auditor General's report, almost 60% of municipalities got disclaimers, and some, the West, let me say unqualified reports, qualified reports, and others disclaimers. Now, for there to be disclaimers, it means there is either unlawful expenditure, there is unauthorized expenditure, there is maladministration generally for the Auditor General to reach a stage where it says that, it gives a disclaimer. It means there is chaos in that municipality. And I would want those responsible, to be brought to book, because if you allocated millions of rands, public money, and you have represented yourself to the public for that appointment as a CFO or whatever, municipal manager, you have represented yourself as qualified. It is therefore inconceivable for you to then, in the management of the finances that have been allocated to you, to come out with a disclaimer. So for me, that should attract some sanction. That should attract some, action on the part of the public protector. And we need to do it quickly, immediately after the public protector, the Auditor General shall have issued the report. We need to zoom into those. That's some of the things that I was talking about, unsolicited investigation, that you do not need to wait for complaints, because obviously people in Vredendal and so on may not even understand that this municipality of ours is embezzling funds or is mismanaging funds. So they may not complain. But given the position we're at, we're able to see that there's a problem and should be able to act without solicitation.
Yes, let me pause you there. The Public Audit Act was amended in 2018 to give certain powers to the Auditor General to do exactly that. Yes. To keep accounting officers accountable and to get sanctions going with regards to that. But the Auditor General is failing to do that. Why do you think a public protector would be in a better position?
Well, I may not attest to the AG failing to do certain things. I may say that perhaps there is just, this issue of maladministration and corruption it's a behemoth. It's a big animal that all of us have to focus on defeating it. And therefore, that is why in the questionnaire I'm referring to collaboration, that the public protector may have to collaborate with various agencies, AG, the police, Hawks, and so on, to make sure that wherever corruption and maladministration rears its ugly head, all of us responsible for anti-corruption zoom into that.
A very serious issue currently on local government level, if we stick to that, is the fact that accounting officers are in contempt of court orders. There's figures concerning that. It's really a problem because they don't do anything about it. You spoke about non-compliance to remedial actions of the public protector. How will you, given the fact that accounting officers are even in contempt of court orders and nothing happens, how will you deal with that situation, given with regards to remedial action?
Well, the courts have a way of enforcing their orders. But as it is, the Constitution says that all this, the courts, the judiciary and the Chapter 9 institutions and all must be assisted by various branches of government to be effective, to be... So it means, therefore, that the public protector should be able to monitor that. Wherever maladministration is concerned and the courts have ruled into that, that should attract the public protector's interest. I know that the public protector may not, look at all the cases in all courts, but wherever maladministration and impropriety is concerned, the public protector should develop interest and be able to follow up. And if the police minister or the police commissioner is not acting per that court order, it should be possible for the public protector to intervene and raise alarm and alert whoever is responsible to act. And failing to act, as I said, an omission is on its own a commission. It's an offense.
Thank you, Chair.
Thank you very much. Honorable Manalisa.
Thank you, Chairperson. Agenda de Kwena. Okay. I think one of the questions are asked by, it's been covered by Honorable Mautwe, because I wanted to ignore the issue of NSFAS and you being the chairperson. What is your understanding of fit for purpose?
Fit for purpose. Fit for purpose involves understanding what is needed, what needs to be done, and yourself having the capacity to fit into the structure and execute what the structure is made for. Because structures are built, but you then find that people who get appointed into those structures to execute those functions are unable or lack the capacity to do that. I have said that I'm fit and proper. I consider myself fit and proper because of the training and the exposure that I've had throughout my life, particularly with regards to the service, public service, in its various forms. So fit for purpose, therefore, means that you've got the capacity and capability to execute what the structure is meant to do. So in case of a public protector, the public protector is meant to combat corruption, maladministration, impropriety, to act without fear and prejudice and all that, And as I've demonstrated, I have done that already, and I believe that I still have the energy and the propensity to do that going forward, serving as a public protector.
Okay. I have noted on your CV that you've been an activist from an early age. So what's your take in terms of the status quo of Chapter 9 institutions in South Africa? Are they doing what they are mandated for constitutionally, or they just comply in terms of their awareness of people knowing them, that they are there for them?
Some time ago, when the late Minister Kada Asma wrote a thick report on the effectiveness or efficiency of the Chapter 9 institutions. And in his report, he proposed that some of them need to be merged because most of them, or all of them, most of them actually, you find that their functions are overlapping. Human Rights Commission and other rights, they're all about rights. CL Rights Commission and all. So it should be possible for them to collaborate, match the budget, because if all of them are pursuing, or some of them are pursuing the rights of people as enshrined in the Bill of Rights, it should be possible to match some of them so that we maximize output. But of course, that is not the function of the public protector. Public protector doesn't make legislation. The report was before Parliament. So I think, as it has happened in the case of the Reserve Bank against the public protector, we don't want the public protector to be found drafting laws and proposing how Parliament must do its work. So we'll leave that to those responsible. But I think that collaboration of some of the Chapter 9 institutions can actually yield better results. And I'm mentioning specifically the Human Rights Commission, perhaps the Gender Commission, CL Rights Commission, because for me, you know, they are splintered. I mean, the CL Rights Commission, I've worked with it in the past as a Deputy Director General of the Department of Traditional Affairs, and I found that even the budget allocation at the time, I think it was about 100 not much, I don't remember the amount exactly, and they would therefore not be able to intervene decisively where the rights of religious communities or cultural communities are involved, linguistic communities and all that. But if they would, say for instance, be integrated into the Human Rights Commission, perhaps the efficacy and effectiveness can be improved.
Okay. Then if you were to be appointed today, what would be your special project as Ntate Queen?
My special projects really would be to identify areas where interventions, particularly, let's say, for me, the implementation of court orders against municipalities. The focus area will be the rural communities. As I said, you know, most of them, they live as if they are second-class citizens. They've got no right to property in the first place. There's no land that rural people can call home, because land in the rural areas, even though you find that the title deed of the farm would be, this is Johannesburg JT number 20, is owned by the community of Abatembu and is held in trust by the chief. I'm just giving Abatembu as an example, or the Ndebele people on behalf of the community. You then find that traditional leaders in those areas regard the land as their land. They behave as landowners. And for me, I think that we need to intervene and give the rural people their titles to the land where they are born and they grow up, so that they can be able to transact based on the land that they are occupying. So they don't only have the permission to occupy, but also have the title deed to those lands. And the kind of levies that our people pay in the rural areas to traditional leaders, that there should be an intervention there. Because there are only three spheres of government, Chairperson. It's local government, it's provincial government, and it's the national government. And this thing that traditional leaders can issue decrees as if they are government, they can deal with the land as if they are government, I think it's an area that needs to be interrupted somehow. So in collaboration with others, I think the Minister of Land Affairs, it will be Rural Development, the Minister of Local Government, COGTA, there should be some action on their part from there. And I think the Public Protector will facilitate that if I am appointed.
Okay, you said
You only have a minute to share between the two.
All right,
Just
okay.
1 minute.
With that minute, your understanding in terms of risk, conflict management and conflict resolutions, your understanding between those two,
Conflict management
and conflict resolutions.
conflict resolution. Well, I'm a lawyer. I'm a practicing lawyer. We resolve conflict disputes every day in court. So that's another way of resolving conflict. The other way is through mediation, engaging people. People resolve among. So alternative dispute resolution, that is through engagement, that's mediation, arbitration. Otherwise, the courts are the final arbiters in all disputes.
Thank you,
Thank you.
Chair.
Thank you very much. It was 12:29 to 12:37. I saw more there looking at your watch. You're still perfectly within your time. Honorable Janchi.
No, Chair, I hope you are the only one checking the time. Quickly, Chair, I think the first thing I'm going to ask you to do as a takeaway note here is to read the report of the Section 194. I might not share some of the things you've just said about that. But the first point I want us to talk about is your understanding of the Public Protector institution. What is its main focus?
Yeah, as I said in the beginning, the origin of the Public Protector is said to be, I don't know if it's true, but it's said to be some Sweden and so on.
Let's make it quick.
Yeah.
Police are known for arrest. The NPA is about prosecution. The Public Protector institution, is it about investigation, prosecution, or?
It's about the investigation of maladministration.
Thank you.
Impropriety.
So I want us to just stay there
Yes.
a little bit. So the Constitutional Court, in the case that you have just shared, the CX, APSA matter, one of the findings there was that the Public Protector had a flawed method of investigation. And that would have happened after you had what we call the Mail and Guardian judgment by the SCA, which indicated that there needs to be an open and inquiring mind. And in fact, Judge Jafta explained what that means, and I want you to help me with that, that it must be open to all possibilities, but he raises two contrasting issues, that it must not be unduly suspicious, but also not be unduly believing. How would you go about trying to balance that as you are praying to be a public protector?
Yes, I've read the judgment, Chairperson. That is why the Constitution, the long and short of that statement by Justice Jafta is that the Public Protector must act without prejudice. Because prejudice means you see Honorable Buthelezi and already you say, perhaps because he's got long beard, he must be.
I'm here,
decent.
Bobotelis. Uzakuphazamisa. Leave him.
Okay. Now, you look at the situation, and without even going into it, already you're prejudiced against. You develop certain ideas about it without hearing. So when a case is presented to you, it should be possible, therefore, to just say, okay, this is a case that is coming my way. I don't know the context. I don't even want to know the context. It's only when I go into it that I will come to understand what it's all about. Because if you listen to people carrying placards and so on.
Thank you. I think you have helped me there. So in other words, evidence must lead you.
Exactly.
Okay. Masishi. My next point. You have spoken a lot about you being fit and proper.
Yes.
So the Constitution doesn't define what fit and proper means. It just says this person must be fit and proper, must be a woman, must be a son, and so on. But a case law in the General Council of the Bar versus Jiba and others, the court begins to define what fit and proper is. Can you share that with us, your understanding, and share a bit of that case law?
Yeah, there are quite a number of them. I mean, the Dudu, Meni, and others.
Just one, no, just the principles that court defined.
So fit and proper means, firstly, it will deal with your qualifications, perhaps academic and all that, but that is not the sole, because there are people who are able to act without prejudice, despite their academic qualifications. So fit and proper, therefore, for me, will center around the ability to act honestly, without prejudging things, the ability to be fair to those who, you'll be dealing with.
Okay. No, thank you. That's my second invitation. When we're done with this, go look at that case law.
Okay.
Issues of integrity, dignity, honesty, and so on. We leave it.
Yeah,
for now.
there are a number of
we leave it
elements
for
that
now.
are stated.
My next point, because I'm pressed for time. Yes. My next point, you seem to have, and I'm happy. I was smiling when I saw that you seem to have read the annual performance plan. I hope the previous annual report.
Yes.
Because you're speaking about the budget of 350.
Yes.
So the first few issues I want to raise out of that. Firstly, in this budget of 350, have you understood the programs that there's a 350 and yet there's an outreach program which is supposed to deal with ordinary citizens? Yes. That's not even a percent.
I've seen that, Chairperson.
And how would you fix that? This is a public protector, not a protector of the elites and so on.
Well, let's say that you have to deal with what you have, firstly.
Okay, so you're going to go in there and then just drive what you get.
No, I'm just saying, in the beginning, deal with what you have. But as I said, I have made, I've seen the proposal by the office now on the possibilities of aligning their office towards how the Auditor General of South Africa works, where, if they're investigating a department or a particular department, then the department must pay for the services that the public protector offer. And I was saying that that's quite a novice idea that we can explore. I have proposed in the beginning, Chairperson, the possibilities of creating a fund, an anti-corruption fund. That will also
that helps. No, you can pause there. I've got that. I've taken note of that, so that you don't repeat it.
Okay.
My next point still on what you have studied. So you spoke about 40,000 complaints. Were you able to come across who the top 5 contributors of that are in that Office of the Public Protector? And I'll tell you, one of them is Home Affairs. Who else in terms of the departments?
Well, I've not done that study, but I suspect local government, the COCTA may be in, and
so that you don't guess.
Yeah, let me not guess.
It's your third invitation.
I haven't done that.
No, we don't guess. It's part of that 40,000. Let's proceed.
Yes.
But I'll leave that to you. My next point, as you're hoping to be the new public protector, come October 16 or 18, 2023, did you come here with some kind of a plan that you can share with us? Just say yes or no first. Do you have a plan, or you just want to be in this position?
No, I have ideas. That's why, among others, I've already been thinking deeply about how do we expand access, how do we expand funding, how do we collaborate with the National School of Government and other institutions. I've identified,
That's
bacons,
fine.
milestones
Help me
that-
with this as part of the plan. One of the things that the country lacks is what is called risk management. We have no risk target around issues of infrastructure, of the next disease after COVID and so on. But let's put it down to the Public Protector Office. What will be your first two risk management plans that you would put into that office, having studied this office through your annual report and the APP?
I think it's
So I allocate 1 minute to the answer.
All right. Yeah, that's very short. I think the turnaround time of cases, because the longer the case takes, the less confidence it gives to the public. People start to lose confidence. As it was said, office divided, low morale of staff. You need to get people to start to jack up. I think the public image of the Public Protector Office has suffered a great deal. You need, therefore, a competent, capable person who will say to the public, I'm here, I know what has to be done, let's get to work. And community, the office is open now. We are no longer going to be spending time in court. We will be dealing with the issues that the public complain about.
Thank you, Chair. We'll watch the space if it's successful.
Thank you so much.
Thank you.
You've done well. Honorable Makonisha.
No, thank you very much, Chairperson. Good day, Advocate Nsewa.
Thank you, sir.
What was the number of people, the biggest number of people that you supervised?
I think in the office of the Premier, I think I was managing about 120 or so. And I was also responsible for traditional affairs. So I had to, secondary supervisees would be the traditional leaders who were also answerable to the office of the Premier. So then in COPTA, the staff in the Department of Traditional Affairs was about 100 in the Department of Traditional Affairs. And in the now in NSFAS and other structures, I'm acting as a board member, so I would not say I'm managing people there. It's a board membership. But the highest, therefore, would have been the Office of the Premier, where I managed more than 100 people.
How did you keep them focused?
It is said that when you are at the top, you manage two levels. Because I was in the Office of the Premier, I was Chief Director, so level 14. So you have to make sure that you manage at least two levels from yourself. So the directors who are accountable to me, reporting to me directly, and their deputy directors. I would make sure that I would want to know how the deputy directors are doing at that level, without undermining the level directly accountable to me. But you would want to, go deeper and understand what they are doing and be able to reach out to them to get them motivated, to get them aligned with your thinking. So I was making sure that, I do not just become an ivory tower and sit there at the top and wait for reports. I would get involved and soil my hands.
Thanks. What is your understanding of the role of the Public Protector in respect of the requirements of the Executive Members Ethics Act?
The public protector is given, as the Constitution says, that he will be given more powers in terms of legislation. Now, the Executive Ethics Act gives the public protector, as it states, what has to be done, what can be investigated in the code. You'll then find that the public protector has to become involved there, as mandated by the Public Protector Act itself and the Ethics Act.
What are some of the challenges associated with the Executive Ethics Act, the implementation part?
I think non-disclosure of benefits. I heard that there are instances where benefits were not disclosed, and I suspect that conflict of interest, well, if you do not disclose, then you find yourself entangled in a conflict of interest, because the reason for non-disclosure sometimes would be because you want to benefit unduly from gifts, from this and that. So that, for me, I think it's a bigger challenge for public office bearers, and we need to ensure that once we get our hands on that and encourage people to see disclosure not as punishment, not as a burden, but as a duty, then we stand a better chance of avoiding that conflict of interest. And of course, confidentiality. I think people should be encouraged to know that if you are given a responsibility that this is a secret of government, this is, it's classified differently, you need to keep to that, because otherwise, even things that are not supposed to disclose get disclosed by people, and because of that disclosure, then it just sort of mixes things up, and it's not good for good governance.
But how will you deal with the issue of the executive administration interface, because you'll be the executive authority?
The Public Finance Management Act in particular, it delineates the role of publics, say, for instance, the CFO with regard to tenders and so on. Let me say supply chain management. Those are delineated by law. The Public Service Act also is very clear on the role of the executive authority as against that of the administration, your DG and so on, delegation of authority and all that. So all these things are very clearly delineated by legislation. But because we are dealing with human beings, people would want to circumvent that, mainly for malicious intent. So that is why I was saying earlier that we may need to collaborate with the National School of Government to ensure that, they emphasize whenever a new administration comes in, there are new MECs, there are new ministers, there are new this and that. The National School of Government should, in my opinion, organize a special arrangement to take them through that, so that we do not assume that they know what has to be done. We take them through, so that when they default, we are able to come with an X.
Yeah, that is when you are externalizing it. But my question is about you being the executive authority as the public protector. And you have the CEO, who is the head of the administration.
Yes, I'll respect those rules as I have outlined earlier. And, additional to that, you find you have the King Code, the King IV Code, which for every manager, those are guidelines, because you do not only have to read the Public Service Act and the Public Protector Act. You need to broaden your knowledge in terms of management, delineation, so that you do not interfere in the operations of the CEO.
Okay. I'm not sure whether you have applied your mind to this issue. Over time, we have experienced that there are always tensions between the public protector and deputies.
And then?
And the deputy. How will you ensure that there is a healthy working relationship with the deputy?
I have referred to delegation of authority, delegations. So I think as we work on the delegations, each of us must know what each has to do. Because if we do not know our roles, then there's definitely going to be a stampede. So let's delineate, let's delegate authority so that if someone then decides to undermine the delegations, then that's something else. But if we do proper delegations of authority, then the conflict will be managed.
Thank you very
Shouldn't be
much,
assumed.
Chairperson. Thank you, Advocate Zabo.
Thank you. Just one last question from myself, Advocate. How would you mitigate tension that may arise between or amongst different state institutions that are mandated to perform a certain functions in terms of their own legislation? For example, Office of the Public Protector wanting to overlap into the mandate of the Reserve Bank, and the Reserve Bank saying it's not a space, or Office of the Public Protector wanting to overlap into the role of SARS, and SARS, this is not a space. How do you deal with a situation like that? Because there is a potential conflict when it comes to the exercise of the mandate of the public protector vis-a-vis the mandate of the other agencies of government. These two institutions that I've just mentioned as an example.
Yeah, Chairperson, the examples that we've given are actual, real conflict that has arisen. And I think the courts have already pronounced on that, for instance. It's about understanding the law, that there is separation of powers. As a public protector, you don't make, it's not within your powers to make laws. As we know, in the case of the Reserve Bank, the public protector wanted to draft some law on what the mandate of the Reserve Bank should be and so on. And the court indeed frowned upon that, because the mandate of the public protector is very clear in Section 182 as expanded by the Public Protector Act. So once you start to want to draft laws, you want to go, say for instance, on the SARS case.
Encroach into other ones.
Yes, on the SARS case, where you want to, I mean, it's clear that if public, the tax affairs of individuals can be made public, you will be encroaching on the rights of privacy and so on. So you need to, therefore, as a public protector, know the law. I mean, that's the starting point, and understanding, interpreting it, and applying it. So
thank you.
That's why
you've answered me. All right, I think we've come to the end of the session, colleagues. I think it's the right time to adjourn. Let me thank you for giving us your time and share your wisdom with the committee. And we wish a safe journey back home. Thank you so much.
Thank you for the committee as well. Thank you.